hard to believe he's not here anymore. We miss him. I'm going to turn you over now to John Finucane. John is defence counsel for John Paul Wooten. John's father was a renowned human rights lawyer, Pat Finucane, who was murdered by police agents for his legal work. John is making a name for himself in the field of human rights law through his hard work and determination. So I'll pass you over to John. Thank you.
Thank you. As already been said, everybody's very welcome, and there are certainly a lot of new faces that weren't here last year. And, unfortunately, there is a need to be here again tonight. Because, as you will all be aware, the appeal was eventually heard in October and was not successful. But it is encouraging, and I'm sure the family see that and take heart from that. And I know Brendan and certainly John Paul will take heart from the turnout that there's been, not just tonight, but the interest that there has been pre-appeal and post. And I think that's a credit to all those who are on the committee for the Justice for the Great Allen 2 group. I probably have the toughest act tonight to try and follow the words of Jerry, but what I intend to do is, I know some people will have quite a great degree of knowledge of the case, others not so much, but what I intend to do tonight is really take us through from the murder itself right through to the original trial, the points that were identified that the appeal was based around, what led to the abandonment of the first appeal, and then what led into the second appeal, how that went in my personal, I suppose, professional opinion, and then the judgment and really where we go from here. And as has been shown on the video, Constable Stephen Carroll was killed on the 9th of March 2009, having attended a 999 call, which was intended to lure police into the area. And when he was in the area, he was sitting in the driver's seat and he was shot by 2 bullets and died at the scene, or hit by 2 shots and died instantly. And it was an area that before my involvement in this case I wasn't really familiar with, but he was killed from a raised area. Certainly the prosecution believed that was the firing point, and there the police found 2 cartridges which had been used as a result of the shooting. Very quickly after that, the next day, John Paul Wooten and Brendan McConville were both arrested. At that time, John Paul was 17 years of age, and there has been a little bit of focus recently, especially with recent arrests, about people being held in Antrim Serious Crime Suite. I think it's not a record I'm particularly happy about having, but I think to my knowledge nobody has been held in Antrim Serious Crime Suite, or certainly he would be up there longer than John Paul. He was held for 13 days. That's 13 days. I certainly don't think McGabbery's a very nice place to be held, but 13 days in Antrim Serious Crime Suite. They have an exercise yard, which is basically a room with some natural air going into it, a room which would probably be the size of about 3 chairs, by 3 chairs, and he was held there as a 17-year-old for 13 days, questioned repeatedly throughout that time. And really at that case, I think it's a fair enough comment to say that it was a degree of rounding up the usual suspects. The witness evidence, which Jerry has already referred to, didn't come until around 11 months later. John Paul would have been a known Republican in the area, and certainly very, very proud of that fact, as was Brendan McConville. And what we didn't know, I wasn't involved in the case at that stage, but what wasn't known then, but was obviously known to the police, was that John Paul had been subject to quite targeted and specific surveillance not by the police, but by the British Army, and his car had been subjected to a tag. It had been attached to the car, and even a lot of the information around that bug, the tag, or whatever you want to call it, remains secretive to this day. And we presume that it was on the exterior of the car somewhere, although I remain sceptical about whether it may have been inside the car on the interior, which will become relevant later on when I talk about the forensic case. The case then, as people will be aware, when you're charged with an offence and they were both charged with the murder of Constable Carroll, the case then progressed through the Magistrates' Court, and the prosecution gathered their evidence with a view to taking the matter to the Crown Court. 11 months later, and obviously I would imagine to the delight of the police, they were contacted very late at night, early hours of the morning, by a man who continues to be referred to as Witness N, who, as Jerry has stated, he says it probably more politely than I will, but he was drunk, he phoned. He was certainly a lot more than inebriated. That was admitted by him. He said that he had information about the murder. And that information was that he was walking with his partner to a relative, and he saw Brendan, whom he knew, or knew of certainly, and at the location, the relevant location, the firing point, in the time leading up to the murder, with a number of other men. He then returned via the same path, and he again saw Brendan there, and this was a shorter time, very, very close to the time of the murder. And really that is where the prosecution case starts, and everything else that comes thereafter falls in behind the fact that that piece of evidence, the prosecution would say, places Brendan McConville at the scene at a relevant time. No evidence to say that he was seen to be the gunman, no evidence, direct evidence to say that he brought a weapon there or brought a weapon away from the scene. But really, once we have, as far as the prosecution case, once we have that piece of evidence placing Brendan McConville at the scene, everything falls in there afterwards. And the trial dealt with those other areas, and really it fell into a number of different areas. The evidence of Witness M was challenged. The weather that night was very, very poor. Weather, you can pick it up slightly from the news footage at the time, but it was very dark. It was March, which, as we all know, isn't exactly the brightest time of the year. Living in the north, it was very dark, it was wet, it was rainy, and the lighting was very, very poor. From somebody who confessed to having poor eyesight, he states that even in that time it was very clear and adamant that he could pick out Brendan McConville. And even if that was the case, obviously it was denied by Brendan that he was there, but even if that was the case, so what? He was in the area, so what? How does that prove that he was involved in the murder? And there was a number of other strands of the evidence that led to that. The other main strand of evidence is what's called CDR or GSR, and that's cartridge discharge residue or gunshot residue. And this then ties in John Paul Wooden's car as well, and they overlap and marry up with each other. John Paul's car, due to the evidence of the tracker, we know was stationed in the area 2 hours and 35 minutes prior to the murder, and remained in the area 10 minutes after the murder. Now, at the risk of sounding facetious, and I don't think you need to be a lawyer, there's not many getaway drivers or not many people involved in the murder of a police officer who would sit at the scene 2.5 hours prior to an attack, and certainly not wait about for 10 minutes after an attack. Common sense would tell you that after an attack like that, people and weapons would have to get brought away. Speed would be of the essence. You certainly wouldn't sit about for 10 minutes, and you certainly wouldn't park a car, in my opinion, up to half a kilometre away, and that's where the car was parked. But the prosecution used that evidence to say that that shows support that there was involvement in the murder from John Paul. In that car, there was a wealth of CDR. There were elements and chemicals that were found in the car in different areas that they said were showed that there was involvement in the murder. And obviously they had the 2 cartridges themselves from the firing point. They had recovered the murder weapon from a house. People who owned that house weren't, as far as I know, weren't arrested, weren't charged. So they had the actual murder weapon, they could confirm that, and therefore they had a source which they could compare and match. The problem that they faced was that the forensics didn't tally up, they didn't marry up. As was borne out through the trial, the way they tested the weapons was amateurish at best, between 2 different forensic labs, both in the north and also in England. It was shambolic the way they tested it. The main prosecution expert at the trial accepted that all of his results could be discounted because of the way that he had tested the weapon. And that's very important. All of his results could be discounted because of the way he had conducted his tests. The Scottish expert who had tested it in England, I felt was very smart in the way that she gave her evidence, and I think she worked from a basis that she wanted every single conclusion to work its way back to a starting point that these two men were guilty, and she refused to accept it, and sometimes became farcical whenever they tried to explain how there was no forensics on a coat that they would attribute to Brendan, and it really got quite farcical when they said, well, maybe the gun was wrapped in the coat, even though the coat hadn't been burnt where you would expect, and the coat wasn't wet either, given the fact that the weather was so bad that night. There was also DNA on this coat, which they attributed to Brendan. There were other people's DNA on the coat as well, and certainly they couldn't say that he was the habitual wearer, that it was definitely his coat. And for example, if I wear my coat now, there will obviously be my DNA on it. If I pass the Claire and she wears it, then her DNA would be on it as well, and certainly there was more than one person's DNA on the coat. But it was another strand in what the prosecution accepted quite openly, was a circumstantial case against both Brendan and John Paul. The tracker on the car, again, was very interesting. We dealt with a lot of these matters before trial, as some of these will be aware. A lot of these matters are dealt with in preliminary applications and hearings around disclosure, and really there was a very strong and robust wall was put up when it came to any questions being asked about the tracker. We weren't allowed to access the tracker, we weren't allowed to have our expert examine it, we weren't allowed to know its full capabilities in the interest of national security. And really where we were coming from was whether there was any potential whatsoever that there could have been any contamination. Anybody who would work for the British Army, I would imagine, would have interaction with weapons, and if they go into a car that belongs to my client, then there would be a very real and live risk that they could contaminate that piece of evidence and that part of the crime scene. We weren't allowed to pursue that. And again, when the British Army personnel gave their evidence at the trial, behind the screen, using pseudonyms, using letters, and I think it's fair to say they disguised their voices at times. They spoke very lowly, or they put on accents. It was, don't ask me, it's somebody else's problem. The tracker was wiped. Well, who would have wiped it? Oh, I don't know. Better asking somebody else. Well, who should we ask? Oh, I don't know. Well, all I can tell you is it wasn't me. We're not talking about, a kitchen and work where anybody can take your sandwiches or anybody can take your tea bags or whatever. We're talking about a very, very secure room in a very, very secure building, manned and controlled by the British Army. There were only a few people who would have had access to that device, and what was accepted as well is that it takes a series of positive commands to wipe the information from a tracker. It's certainly not as simple as hitting the wrong button, and it would take approximately, I think, 10 to 12 minutes before you can wipe material. But certainly material was wiped from that tracker, something that I would describe as suspicious in the hours after they would have known a policeman had been killed, and something that I would say would throw more doubt into the weight that should be attached to that piece of evidence. On top of that as well, we had the bad character, and I use that term very, very loosely, of both Brendan and John Paul. The bad character that was referred to by the prosecution was basically being an open Republican and not being ashamed about it. Membership of bands, taking part in colour parties, all of which are entirely legal, entirely lawful, entirely governed by the European Convention on Human Rights, and enshrined in lots of different political documents from the UN to Europe to within our own law, which enacts the Human Rights Act. People have freedom of political expression, but that was used in a way which I think, without trying to touch on the other areas that I believe are problems, that really what the prosecution were tactically trying to say to the judge, and only the judge, because obviously it was a block case, was that these are bad boys. You need to trust us. They're dissidents. They're involved in dissident behaviour in colour parties. They're bad boys. Just take our word for it. And the problem was that the judge did take their word for it, despite hearing the evidence of the trial, where I think a lot of the forensic evidence was undermined. I think the evidence of witness M was undermined, and I think a lot of this is actually on the website of the group, and again, people can read this for themselves. And that's something that we've always said from the start. If you don't believe me or you don't want to take my word for it, read the paper, read the evidence yourself. but it was quite clearly undermined. The judge convicted both Brendan and John Paul. Sentenced John Paul without ever really attributing a role, and obviously Brendan's role was defined by the evidence of witness M, but nobody could ever really pinpoint what John Paul did, but yet he finds himself convicted of murder. They could say for certain what he didn't do, and this was accepted by the prosecution. They could say for certain that he wasn't the shooter. They could say for certain that he wasn't at the scene, but that he provided some sort of logistical support. Now, there are lots of different leaps that you have to take here legally to find somebody guilty of murder with regards to logistical support. Is that if I provide a car, I have to know that it's going to be involved in something. If I take a car away, I have to have a fair idea of what it's been involved in. And they were able to make those evidential leaps. The judge was satisfied. He didn't have one doubt in his mind, as we all know the test is if there's a reasonable doubt. He didn't have any reasonable doubt, and he was quite happy to say, you did something, so I'm happy enough to convict you of murder. The sentence was then passed, and he sentenced Brendan to 25 years minimum tariff, and a life tariff with a minimum of 25 years, and John Paul again to a life tariff because he'd been convicted of murder, with a minimum term of 14 years. What followed in the days after that, I think it was a Monday or a Tuesday that the sentence was passed, what followed after that was really a media hysteria about awarding, or there's a poor choice of word, but handing down a sentence of 14 years for somebody who was guilty of murder. And really, I think the media failed quite spectacularly in the way they reported the trial in the first place. Very little of the evidence was reported upon, very little of the cross-examinations that were detrimental to the prosecution case were ever given any light of day. And that was really echoed by the fact, and underlined by the fact that they then had this reaction, initial reaction to the sentence of 14 years for John Paul. What then followed was unprecedented, and sadly not the first unprecedented thing that I've ever seen to do with this case. People say in football, don't argue with the referee because he's never going to change his mind, you know, just get on with it, you just deal with it. Well, in this case, for the first time, certainly that I'm aware of, although I'm quite young, the two QCs in the case, Arthur Harvey and Barry MacDonald, or Brendan Kelly at that stage, had never heard of before. The judge then came out a number of days later and publicly explained, brought everybody back, explained why he had to give John Paul 14 years, and really that he felt his hands were tied behind his back. And it was very surprising that a judge came out and explained his decisions like that, and I found that it was very much a reaction to the public outcry, initial public outcry, because I think by the Friday that we were back in court, people had started to realise, well, we're dealing with a 17-year-old. The law would say that somebody who is 17 is a child, and they should be dealt with differently. And when you deal with somebody that you can't even attribute a role to, then that has to be reflected in the sentence. But the judge did this nonetheless, and I think it was part of the tempo and the context that has been there really throughout this case. So we didn't really need to take too many instructions from John Paul. We knew that the appeal would be lodged, and the appeal was lodged. Subsequent to that, the PPS, probably on the back of that initial public outcry that I referred to, and I don't think based on any sound legal reason, indicated that they would appeal. They would refer the sentences of both Brendan and John Paul. They said that 25 years was too lenient for Brendan, and they said that 14 was too lenient for John Paul. We had heard from the prosecution counsel, and certainly from the PPS representatives, that they wanted really a starting point of 40 years for Brendan, and at least 25-30 for John Paul. So whilst that was in the background, the court, in timetabling the appeal, said we will deal with the appeal against conviction first, and if that is unsuccessful, we will then deal with the PPS reference. So the appeal was set, and again, I see Brian Shivers here, and for pointing me out, but appeals are normally very, very short. No matter how big or how spectacular the case, appeals, the Court of Appeal here want the points distilled, and sometimes cases that can run for weeks and weeks, the appeal could last half a day, or sometimes a day, but really it is not a re-examination of all of the evidence. Because of points that we had an automatic right of appeal because it was a diplock case, but there were 7 other strands over and above that. The likes of witness M, the DNA, the cartridge discharge residue, the weight that was put on, the inference, the lack of Brendan and John Paul giving evidence in the trial, the tracker, the sightings of the Citroen car and the bad character that he used lately. All of those points in themselves were strong enough on their own to have an appeal. We had these all together, so it was a very strong appeal, and there were lots of different legal issues involved. So I think around 4 or 5 days were set aside on the 29th of April 2013, and that was, I think that was a Monday. That was due to run from Monday to Friday, which in itself would have been one of the longest appeals that the North has seen over, well, certainly that I'm aware of. Leading up to that, there was a witness who came forward, and obviously would have been relevant to Brendan specifically, but given the fact that Brendan's connection to the scene is the first evidential domino in the case, it had an impact on John Paul as well. A witness came forward to say that he could undermine directly the evidence of witness M. That witness is now known as witness Z. And he could say that witness M would not have taken the route that he took on the night, that he would not have been going to visit him as he had said, that he was known within his family as a Walter Mitty, that there were difficulties with him, that there had been incidents in the past that really made witness M somebody who was very, very unreliable. And in his evidence by affidavit form prior to the appeal, he explained his reluctance to come forward the first time because he thought that witness M was so unreliable he wouldn't have had to have come forward. No court could possibly have believed witness M and convicted 2 people of murder on such weak evidence, taking into account the other weak evidence that was supporting them. But he obviously saw the fact that there was a conviction and came forward. He had provided an affidavit, and that affidavit was served on the court and also on the PPS. Unbeknownst to us, prior to the 29th, the PSNI went into overdrive. The dictionary definition of what the police should be is that they are an investigative body only. They gather evidence and they provide that to the PPS. More and more I'm yet to see the PSNI live up to that dictionary definition, and they certainly set about protecting the prosecution case, their case, at all costs. And what happened was that witness said was arrested on the Friday prior to the appeal. He was held, I think, until the early hours of the Sunday morning, interviewed 10 times in a police station, and he was interviewed for withholding information, potentially referred to the course of justice. During those 10 interviews, not one piece of evidence was put to him. He was released without charge, and that led to the headline that was shown in the video where Jerry spoke, that on the Monday, the star witness that would be used by the defence to undermine the main piece of evidence for the prosecution had been arrested, and very understandably was very reluctant to come to court, given the fact that the PSNI had used such bully boy tactics to intimidate a witness and frighten a witness off. And I think send a very clear message, not just to that witness, but to any witness, not to interfere or mess about with a prosecution case, especially when you're dealing with the murder of a police officer. What happened on the 29th, again, I think is unprecedented. I sort of stand to be corrected that an appeal has been abandoned in such context before. The QC for Brendan, as I've said, made it very clear to the court and spoke very robustly that he saw this as a very deliberate attempt to undermine the prosecution, or to undermine the appeal, to sabotage the efforts of their work. And the prosecution counsel on the day seemed to be taken by surprise that this has happened. Whether or not you believe that or not, I don't know, but I think that it may well be correct that the police took this as a solo run and decided that they were in charge of this case, and they would decide who wouldn't give evidence. The appeal was abandoned on the 29th. It simply couldn't run. There was so much more material that we were being made aware of. And the material that that did transpire between April and when the appeal did eventually run in October, again was shocking that there was a very focused, undercover, covert operation against witness Z, against his family, against his friends, and against the legal team that was attempting to speak to him. Houses were bugged, people were watched, bars were bugged, cars were bugged, transcripts were made, and sometimes they would be in focus to these people to let them know that they were there, that they were watching. Again, these are representatives of the state. This is where your tax dollars are going to pay for a police service, and these were the actions that were being taken. An application was made that the investigation of this should be taken away from the PSNI and given to the CCRC. That ultimately wasn't granted by the court. But we then found ourselves with additional limbs to fight the appeal with. Another matter that came to the attention of the defence, and it's something that some people may be aware of, and I know certainly I mentioned it before when speaking about Brendan, was the note of the governor's details that was found in Brendan's cell. And Brendan was arrested and interviewed, I think maybe charged, I'm not sure whether he was charged, but certainly he was investigated for that, about dissident Republican on remand for murdering a police officer. I think he had other charges at that stage as well, which ultimately collapsed. Having the governor's details. Now, as we all know, there was a very clear agenda within McGabry at that time, that the governor at that time, Mr. Radford, wasn't too popular because he was attempting to bring in changes. And the prison ombudswoman, Polly McCabe, investigated the note in the cell, and obviously Brendan denied any knowledge of it, and the only explanation was that it could be planted. And she supported that view. She came to the conclusion as well that the note had been planted, and it had been planted by a prison officer, and quite deliberately too. Now, the reason why this then becomes important for the appeal is that it then transpires that the officer in charge of the investigation into the murder of Constable Carroll purposely took on the investigation regarding the note in the cell, and comments were made to the prison ombudswoman that it would certainly be helpful if the note could be attributed to Brendan, that would help the appeal, it would help bad character, it would help creating a context and an image of a man who would be a lot easier to say was part of a murder conspiracy against Constable Carroll. And what then followed was an appeal, which I think is, I've been told that the only other longer running appeal is the Supergrass appeals of the 80s, but that was an appeal that dealt with many different defendants, so the numbers in themselves. But an appeal dealing with 2 defendants ran for 9 days in October. Witness evidence was called, which again is very unusual. The court heard from witness Z. The court heard from the investigating officer, DCI Ricky Harkness, who was the person that we alleged had carried out his role in bad faith, to put it politely. And the court also heard from former prison ombudswoman Polly McCabe and the former governor of McGabry, Steve Radford. It's very hard, and the people who were there at the appeal will get this, and I'll struggle to get across. I suppose it's slightly embarrassing as well because it didn't work out too good, but really the appeal couldn't have went any better. The interaction from the judiciary towards the defence, the way they attacked the prosecution case, the credible way in which witness Z gave his evidence, the very weak excuses and forgetfulness that sometimes, amnesia is a very funny thing, it seems to always hit police officers when they go into a witness box. And this police officer certainly was no different at times and had a very different recollection, if any recollection, of certain incidents. And then we have a former governor of McGabry and a former prison ombudswoman who gave very strong evidence, all supporting the defence hypothesis that was being put towards them. The lack of any room for John Paul was certainly taken on by one of the appeal judges and was put very robustly to the prosecution, who couldn't provide any answer. And what the prosecution kept saying was, yes, strands of evidence in this case on their own are probably not enough. We can't say what John Paul did, but when you put all these strands together, that's where we say it's enough to dismiss the appeal and say that this conviction for murder is safe. So the appeal finished, and at one point, and again, I'm not too embarrassed to say this, I wasn't the only one. At one point we thought the case was going to collapse in the middle of the appeal, that the prosecution were so much on the ropes, and I know certainly anecdotally since they have accepted they were on the ropes, and they thought that they may well, that the case may well be taken away from them, but the court didn't step in. It was a sentiment that was shared by both legal teams, and I think certainly by John Paul as well. He's far from stupid and he can see the evidence himself, and you know he saw it for as weak as it was, and it was being highlighted to be as weak as it was. And again, credit to the group and the campaign. This case was being fought in a very different context, and this time there was proper media reporting and a bit more scrutiny on the strength of the evidence. So the appeal finished on the 17th of October, and the way appeals work, appeals just finish and the court will contact you. It's not like a Crown Court where you're given a firm date where you will get judgment. We waited and waited and waited, and really it was only as a result of pressure from, or well, certainly queries from the Irish News that sort of g'd the Court of Appeal along to actually give a decision. And Brendan and John Paul were kept waiting for approximately 7 months, which I think again is a very long time to be kept waiting, especially given that the first appeal was due to be heard in April, and the conviction was going back to March 2012. You're talking over 2 years before they were finding how their appeal went. And the judgment, for me, is worlds apart from the feeling that was in that court, from the way the judges interacted. Sometimes judges are very hard to read. They just sit there, they say very little, they listen to the evidence, and they go off and make a decision, and it's a flip of a coin as to what way you think they'll go. For me, they saw that case for what it was. How they have dismissed the evidence of Zed, how they have dismissed the evidence of Pauline McCabe, how they have dismissed the evidence of Bradford, and how they have stood over what remains to me a very, very weak forensic case, a very, very weak eyewitness case, and upheld the conviction. It is beyond me what they have, and they did it quite forcefully as well. It was an absolute robust dismissal of really every defence point that was put throughout the 9 days of the appeal. We didn't really have time to cry over that, because we then had the reference to deal with, which then became active because the PPS were now coming back in, and it was the head of the PPS himself, Bar McGrory, who changed the counsel who had dealt with the appeal, and he put himself in to deal with the reference when we were arguing in court about whether Brendan and John Paul's sentence should be increased. Quite quickly, after an hour or so, the court refused leave for Brendan's sentence to be increased, and at present he remains with a tariff, a minimum tariff of 25 years. They did permit argument on John Paul, and so the Director of Public Prosecutions argued that it really should be up well into the 20s, and not that much behind 25, if at all behind it. And we fought that on the basis that we're dealing with a 17-year-old, we're dealing with the lack of any subscribed rule, we're dealing with comments that are attributed to a 17-year-old 5 years later, and looking to hang a guy for comments that he may or may not have made as a youngster. And I think, well, certainly speaking for myself, I don't know about people in the room, but you say things sometimes when you're 17 out of context, and for that to remain as a reason why your sentence should be increased for a murder, which I think you're firmly innocent of 5 years later, I think smacks is slightly perverse, but it's something the PPS wanted. There's no decision on that. We'll be back in court in September to hear whether the Court of Appeal will increase the sentence of 14 years. I think given the way this case has gone, I would be somewhat surprised if they don't increase it from 14 years. The fact that they allowed it to be sent a message, I may be wrong about that, but as I say, I would be surprised if it isn't increased. So legally, where we go from here, with regards to the conviction itself, with regards to the fact that we have 2 men in jail for a murder, which quite frankly the evidence doesn't support, or that they should be appealed before a court, but that they are innocent of. The more you go down the path, the less options you have. As I say, when they were convicted at trial, they have an automatic right to appeal, and they don't enjoy that luxury now. There are two options for them. One, they can go to the Supreme Court, but you can only go to the Supreme Court in England on a point of law. You can't go because you disagree with the facts that the court have found. Questions are before the Court of Appeal, and they have to give permission for the questions to be certified for the case to go to the Supreme Court. If they refuse that permission, then you can petition the Supreme Court directly, and they will decide whether they will accept your case and hear your point or not. And then, in tandem with that, there will also be an application to the CCRC, the Criminal Case Review Commission, who do have investigatory powers and who will be looking at the case again on the strength of the evidence. But their options are really only those two, and that's really where we find ourselves on the legal situation at this stage. As somebody who has had experience with campaigns, I think it's very important, hopefully, but there might be some people in here who are wondering, well, what can I do about this? And I think that never be put off by what political agenda or what political muck may be thrown at this campaign, in the sense that it's for dissidents or whatever. Certainly I've seen people who are accused of other offences who have had pictures of them holding up a Free Colin Duffy poster, and that's being used as a reason to refuse them bail whenever they're exercising their lawful right to protest about something that they feel strongly about. So despite the state's actions, I would urge everybody not to be afraid and not to bow down, because they don't want attention to this case. That's very, very clear. But a campaign will strengthen any legal avenue, and I've seen that work personally in relation to my father's case, that really lawyers can only do so much, but the strength of a campaign behind a legal team is worth its weight in gold, and doesn't go unnoticed. And I think that is the reason, one of the reasons why the appeal allowed 9 days for the appeal itself in October. Obviously they came to a conclusion I think is flawed, but they realised that there was a lot of focus on this, a lot more than there was at the trial. So again, I'm happy enough to take any questions. It was quite general with regards to the overview of them, but I thank you all for coming here.